Whenever you're ready.
Thank you, Your Honors. Still good morning. Good morning, Your Honors. John Galwin of Bassbury and Sims, and I represent Buchanan Dunavant, the appellant in this matter. I'd like to reserve 4 minutes of my time for rebuttal, if permitted.
4 minutes, okay.
Thank you. So, Your Honors, on March 17, 2025, the Tennessee Supreme Court ruled, and I quote, "The Court of Appeals judgment is vacated and the case is remanded to the Court of Appeals for further consideration in light of Pharma Conference versus State of Tennessee." Of course, on March 20th, 25, this court directed the parties to submit supplemental briefing and request oral argument on the remanded issue. In the present case, in the Dunavant case, this court filed its opinion back on September 17th, 2024. And in it, this court affirmed summary judgment for respondents. In the opinion, the court agreed with Judge Hurd that the MDA at issue was, quote, "too vague and indefinite to be enforced." And then 3 months later, after Your Honor's opinion from this court, the Tennessee Supreme Court rendered its opinion in Pharma, reversing this court's affirmation of summary judgment against Pharma Conference Education adverse to the state of Tennessee. Thus, this court didn't have the benefit of the Supreme Court's Pharma opinion when it ruled back in September of 24. The sole issue today on remand is what is Pharma's bearing on Dunavant? And I think there are 4 general or principal areas where Pharma dictates reversal of the opinion from 1 year ago.
If you're correct and Pharma dictates reversal of the last Dunavant Court of Appeals opinion, does that mean we go forward and address the other issues that were pretermitted by that opinion?
So the issue of arbitrary disinheritance was pretermitted. Looking back at this court's case in Lake, which I think was a Judge Stafford opinion in 2012, where there was a remand from the U.S. Supreme Court, this court noted that it interpreted the remand very strictly, but the issue before the court is the one on Pharma with respect to its impact on this case.
So we just issue an opinion on Pharma, and what happens to the other issues then?
Well, I can address arbitrary disinheritance as part of my argument, Your Honor, but I think that on remand, there are genuine issues of material fact as to that point that are going to have to be litigated and tried in the case below.
You mean remand to the trial court?
Yes, absolutely.
Okay.
Your Honor.
But don't we have to first address those issues since they were raised in the initial briefing to the Court of Appeals that resulted in the opinion that was vacated and remanded to
Yes,
us?
I think the appellant would appreciate as much guidance from this court before the remand to the trial court on all of these issues.
That's why these other 2 guys are here. They're really smart.
Thank you, Your Honor. The Supreme Court's holding on illusory demands reversal in Dunavant. The court in Pharma considered whether Pharma's promise to produce pharmaceutical continuing education programs, quote, "as is feasible," constitutes valid or adequate consideration. The claims court had reasoned that Pharma's promise to hold as many programs, quote, "as is feasible," was illusory. And the Supreme Court noted in Pharma that an illusory promise is too indefinite to be enforceable. Similar to Pharma, respondents argued on summary judgment in this case that, quote, "provisions of the MDA at issue are simply too vague and uncertain to be enforceable." The Supreme Court in Pharma held that courts generally endeavor to avoid finding that a promise is illusory. In finding that the pharma contract was not illusory, and thus there was adequate consideration, the Supreme Court relied in that case on Tennessee Code Annotated 4750-103, which says, of course, if the contract's in writing and it's signed by the party to be bound, that there's a presumption of adequate consideration. Because the pharma contract was in writing and signed by the parties, the court recognized the presumption and found that there was adequate consideration under 4750-103. Now, on remand to this case in the supplemental briefing, Respondents' Counsel remarkably argues in its supplemental brief in 2 spots on pages 4 and 5 that there is no such provision that presumes formation of a contract. Of course, that's wholly incorrect because 4750-112A provides in pertinent part that all contracts in writing and signed by the party to be bound shall be prima facie evidence that the contract contains the true intention of the parties and shall be enforced as written. In this case, similar to pharma, Mr. Dunavant's signature on the written MDA was prima facie evidence of an enforceable contract. Nothing in the record rebuts that. Thus, pharma fully supports the fact that the MDA in Dunavant is not illusory. It's not too indefinite. And further, in reversing, in vacating this court's affirmance of summary judgment in pharma, it's noteworthy that the Supreme Court also relied on Restatement Second of Contracts 33, which provides, and I quote, "The terms of a contract are reasonably certain if they provide a basis for determining the existence of a breach and for giving an appropriate remedy." In pharma, they called this the objective feasibility standard, saying, is the contract one that enables a reviewing court to determine whether a breach occurred? And respectfully, I'd submit that the record is undisputed here that Mr. Dunavant had 2 obligations under paragraph 3B. One was to create an irrevocable trust, and 2, to fund it with an amount equal to the average after-tax value received by the 4 older siblings trust referenced in 3A.
So when would that amount be determined, Mr. Gunn?
So we were not allowed to do discovery on those trusts and the dates that they were received. But for purposes of contract formation, Your Honor, all that pharma informs us is that if this court can find that Mr. Dunavant did not create an irrevocable trust, as outlined in 3B, there's a breach. And the rest becomes a question of damages to be proven at trial. And we have employed an expert who, despite our limited discovery, has come up with a baseline number on what that amount would be. We only know from the record in another case that those funds were received by the other 4 siblings, or at least one of them. So we know, we just weren't permitted discovery on that, Judge Armstrong.
And that's, go ahead.
If Mr. Dunavant acquired a life insurance policy that made your client the beneficiary, and the amount that would be paid to him would equal the average of those 4 for the older kids, would that satisfy the requirement of the MDA?
If I understand your question correctly, yes. That his contractual obligation under 3B was to fund the trust with an amount equal to the average of the after-tax value received by the other 4 siblings, a definitive number that can be ascertained and proven at trial by our expert.
And when was the last date that that number could be ascertained? As I understand, those are going to be paid out when those older kids reached age 30. When did the youngest of the 4 reach age 30?
1993, Your Honor.
1993.
Yes, sir.
And so we would have amounts for all 4 by that time.
Again, Your Honor, I was not permitted to obtained that discovery in this case. We were able to piece together from the stock ledger, since most of the assets in those siblings trusts were DEI stock, our expert was able to come up with a baseline number. But on remand to the trial court, if we're permitted to do our damages discovery in full, we can certainly find a definite number for that.
I was curious, when did the breach occur in this case, in your opinion?
Well, Your Honor, Mr. Dunavant died on September 11th, 2021. Judge Hurd ruled, it was her ruling that he had until his death to complete the contract.
Isn't the normal rule that if a time element is left out of a contract, that the courts presume a reasonable time?
Yes, sir.
Was that what the judge did? She presumed the reasonable time was the end of his life?
Well, in fact, Judge Bennett, we argued that a reasonable time would be far shorter, but that was her ruling. That
Okay.
I don't believe she ever articulated in an order specifically that the date of death was the reasonable time. I don't think she used that
I
language.
didn't see that either, but
Yeah.
I thought maybe I missed it.
Right.
At the minimum, it's a point of no return for life insurance.
Well, that's for sure. So, and I would just like to say that PhRMA also informs that this contract is sufficiently definite in all the other terms that they said were lacking. If you look at the four corners of the opinion, it makes clear that so many numerous elements or details were left out, and in PhRMA, that contract was held to be enforceable. I think I'm out of time, but I've got.
You are, and when you come back up, I want you to address this issue. Aren't we talking about two different things, a meeting of the minds and a lack of essential terms? And does PhRMA really talk about that when you look at the order of the trial court? Because the trial court's, at least in my reading of the trial court's order, uses those terms interchangeably, and it's somewhat confusing as to whether we're talking about meeting of minds or lack of essential terms.
Right.
Or lack of definiteness.
The seminal case of Doe versus HCA outlines the 5 elements, and so what's happened is there's a confusion between element 1 and element 5, which is enforceability. And
I'll let you address that further in your
Will
rebuttal.
do.
And I hope you'll address the motion to consider post-judgment facts.
Yes, sir.
I know we've given you a big assignment for your rebuttal, but
I'll do my best in 4 minutes.
thank you.
But we've given him 15 minutes to think about it.
That's right.
Good morning, Your Honors. My name is Matthew Geel. May it please the court. I'm from the Memphis Bar, and I'm joined today by my partner, Jeff Feibelman, as well as my co-counsel, Blanchard Toole. The court, frankly, got this one right. Both the trial court and the Court of Appeals correctly determined that the language at issue in this contract is too vague, uncertain, and contradictory to be enforceable.
With all due respect, I think there are 5 people who may disagree with that.
Only 4, Judge, because Justice Wagner didn't participate. And I will say that the order that was filed by the Tennessee Supreme Court was very brief. And to address one of the points made by Mr. Galwin, kind of as a threshold issue about what this court can and cannot consider at this point, it simply states that the court should consider its opinion in light of the recent decision that was not available to the Court of Appeals. There's no limiting instruction that the only thing to look at is enforceability. The question of whether or not Mr. Dunavant had non-arbitrary reasons not to create the trust are squarely before the court in light of the Tennessee Supreme Court's order vacating this court's opinion. There's nothing in the order specifically saying that the court got it right or got it wrong. It was simply a remand to this court to do the legwork for the Tennessee Supreme Court in light of a new opinion, and allowing this court to make a decision about, does this opinion in fact dictate the outcome in this case. Frankly, I think that the case is both legally and factually distinct from our case at bar. Pharma specifically dealt with consideration, and yes, there is overlap kind of in the terminology, because the question there was whether or not there was an adequate promise. The question was whether or not an illusory promise can therefore be consideration. But that wasn't exactly what was argued here. It wasn't just that it was an illusory promise. It was that the language at issue was so vague, so uncertain, and in fact contradictory, as this court noted in its vacated opinion, that there are terms that are directly contradictory in the agreement to the interpretation that the petitioner continues to assert, even at this point in the supplemental briefing phase of the opinion. I was surprised that Mr. Galwin cited to the restatement second, which was also cited in Pharma, where it says the terms of a contract are reasonably certain if they provide a basis for determining existence of a breach and for giving an appropriate remedy. That's the part that's missing here, the second part. There is no way to determine an appropriate remedy based on the contractual language at issue. The language is so
But you can supplement that through discovery and ascertain that figure, right?
Frankly, Your Honor, I don't think that it's possible. And there's a few different reasons for that. And if you look at the actual language of the agreement, the question is figuring out what is the obligation, and what is the obligation kind of dictates what is the remedy, and what are the amount of damages. And the problem with this contract, and the problem that has always been there, that has stumped every court that's looked at it along the way in detail and analyzed it, is that the contract talks in terms of different items. In paragraph 3B, the part cited by Mr. Galwin, where the trustee will hold for petitioner's benefit an amount equal to the average of the after-tax funds received from the other four trusts. Well, the funds are in direct contrast to what was actually in the other four trusts, because those other four trusts didn't hold, it wasn't cash holdings, it wasn't, stocks or other types of mutual funds, things that are more liquid. No, it was simply stock of DEI. And so what the problem is...
But you can put a monetary amount on that stock, can't you?
You can if you can determine the amount and the time period when that was supposed to occur, but that's not specified in the contract. And additionally, what's not specified in the contract is the way that determination or distribution was ultimately supposed to occur from the trust. All it says is that the trustee will hold for Buck's benefit an amount. It doesn't say anything about the standards or timing for distribution. And these are issues that this particular court noted in its last opinion. It's illusory in a different sense than the contract in Pharma. It was that ultimately there was nothing in this contract requiring that this trust actually ever be for the benefit ultimately of the petitioner, because there were no standards or timing for distribution.
Well, it says it's for the benefit.
It says that the funds are to be held for Buck's benefit, but there's no directive that the funds actually ever be distributed
Well, isn't that kind of absurd to create a trust that can't be distributed?
I don't think it's absurd in light...
And aren't there plenty of terms out there, understandings of what trusts do, and that a court could direct a trust as to what its standards are?
Yes, Your Honor, there are other terms out there. Typically, contracts that deal with trust specify those types of terms, though, for this very reason, is because standards and timing of distribution are very specific to what the person creating, the grantor of the trust, wants and intends.
Well, apparently the grantor of the trust didn't want or intend anything particular, or they would have said so, would they not?
I think that's exactly the problem. I think that because there's that lack of an explanation of what was intended here, it's clear that there wasn't a true enforceable promise because of that uncertainty. I think we come back to that very problem, is that it just doesn't do anything. It doesn't explain what needs to be done. And you have this kind of contrast. And I was surprised in kind of the responses to Judge Armstrong, your questions to Mr. Galwin about the timing. You asked what was the time where this would have been determined, and I think you kind of asked whether it would be 1993, but that's not what they've argued. That's not what they've argued here. That's not what they've argued down below. It's not what they've argued in their supplemental briefing before this court. Repeatedly, the petitioner has argued that the time to determine what the, quote, after-tax funds received from these trusts is when the stock was sold, whether or not the stock was sold when the stock was actually distributed from the other four trusts. And so repeatedly, they have tried to argue that there would have been some sort of a continuing obligation for Mr. Dunavant, the deceased Mr. Dunavant, to have kept up with, this stock after it was distributed through these other trusts. Well, what was that stock sold for? That interpretation that they have repeatedly and consistently argued at every stage of this litigation is directly contrary to the plain language of the agreement. Because the plain language of Section 6A states that husband shall have no further responsibility with regard to life insurance except to maintain the insurance for the benefit of Buck above described. And the insurance for the benefit of Buck that was above described is, quote, husband has arranged to provide life insurance for his benefit. That he had already arranged to provide that life insurance. So the direct language of this is that he could not have had some sort of continuing obligation. And so you end up with this contradiction of, you have an obligation that's poorly defined, you have an obligation that compares funds to assets, and you have language in the actual agreement that says that there is no possible way, or that he has no duty to buy further insurance. So if the stock of Dunavant Enterprises goes up, and the time period where I think you're right, Judge Armstrong, that the latest possible time you could ever look at this is 1993. But even if you look at it in 1993, if the stock went up from the creation of this 1975 MDA in 1993, well, he didn't have a duty to go out and buy additional insurance. He had a duty to maintain what had already been arranged for the benefit of Buck. And so again, you end up with a contradiction in what the obligation is and the express language that was agreed upon by the parties. I think the secondary question, if the court ultimately determines that there was an enforceable obligation, is to look at the alternative finding that Judge Hurd made below. And that was that 3D must be read in concert with paragraph 3B. All of these provisions fall under paragraph 3, which is entitled inheritance. Paragraph 3A deals with the trust of the four other siblings, and paragraph 3B is titled inheritance of Buchanan, Dobson, Dunavant. Paragraph 3D, meanwhile, deals with inheritance. Specifically, that is the title, and it talks about how husband acknowledges that none of his 5 children will be arbitrarily disinherited.
So how can you argue that failure to create the trust under 3B is not an arbitrary disinheritance?
Absolutely, Your Honor. It's easy. There are numerous undisputed facts in the trial court record.
But there's no document that he disinherited Buck Dunavant under that provision.
So what I would say, Your Honor, is inheritance in this context is inheritance under the contract. And so all of the provisions...
And why would it be? How can you disinherit someone if you create an irrevocable trust?
You can decide not to create the irrevocable trust.
But there were 4 irrevocable trusts already created, were there not?
There were, that had already been created.
So you can't disinherit from those?
100%, and that's what the court ruled in the other action, is that there was no possible way that the petitioner's sister could have been disinherited, period, whether arbitrary or not.
That means D has no meaning as to an irrevocable trust.
Absolutely not, Your Honor. It has the one meaning, the only meaning that can be given to it to avoid making it completely surplusage is that it applies to paragraph 3B. And that there was a trust that had not been created under paragraph 3B, and that under 3D, he had the right to non-arbitrarily decide not to create the inheritance of the
And how do we know it was non-arbitrary?
Because that is undisputed in the record. He created a trust document, a testamentary document, where he laid out all of the reasons why he provided for the petitioner in the way that he did.
He laid out a trust document that disinherited Buck from a separate living trust.
I believe
It was very specific.
I believe the testamentary document lays out the reasons why he treated Buck the way that he did in all of his testamentary.
Well, we don't have that kind of information, do we? He didn't say in his will, by the way, I'm disinheriting Buck from the MDA living life insurance trust I was supposed to create because of these reasons. There's nothing out there that I saw in the record that says why there was no trust created.
Your Honor, I don't know that you need specifically that type of language to understand why the creation of the specific trust in paragraph 3B would not have been would have been non-arbitrary. And because he lays out the reasons for the way that he treated the petitioner in his testamentary documents, that same testamentary intent and non-arbitrary reasons that he provided would explain that same reason not to create the trust specifically
Were there other
mentioned.
trusts that Mr. Buck Dunavant benefited from?
Yes, there were, Your Honor.
So that the language from the William Dunavant Living Trust that he put in, the plethora of reasons plethora of things that Buck had done wrong in his life, that wasn't applied to other trusts, then was it?
Those were part of the reasons why it's non-arbitrary for him not to have created the trust in paragraph 3B. He did create a life insurance trust that benefited Buck Dunavant in the amount of over $1 million. That's undisputed. He did in fact create that, a life insurance trust, and that was part of, again, the overall picture.
But I just don't see, you want to interpret that one trust where he was clearly non-arbitrarily excluded. It's clear. You want to interpret those reasons as applying to the MDA trust because it wasn't created. But what difference does it make? I mean, you didn't apply it to other trusts that he benefited from.
Your Honor, all we can do is look at...
You can't take one and select, okay, we'll disinherit him from this other one, but we won't disinherit him from these other two.
Your Honor, I think that's the only way that we can do it at this point. Mr. Dunavant
Well, that
is
sounds arbitrary to me.
deceased. But it's not arbitrary. I mean, he provided a number of reasons for the way that he treated Buck Dunavant, specifically dealing with inheritance, trust. There's, unless he had, you're right, created a document that specifically said, this is the way that I did this under this contract. I decided to do it that way for this reason. But that's not what's required to show that it was arbitrary or non-arbitrary. All we have to prove is that Mr. Dunavant had non-arbitrary reasons not to create this trust. And those same reasons that are provided in his testamentary documents are applicable to why he wouldn't have created this particular trust.
But in this instance, Mr. Dunavant was still alive when this litigation commenced and was alive for a year or so thereafter, and he could have easily disinherited him. Could he not?
I think he did, Your Honor.
I mean, he could have more clearly disinherited him, assuming what you're saying is accurate.
I would agree that, that he could have been more clear, but I don't believe that would have been necessary in order for this court to find that the undisputed facts show that this was a non-arbitrary decision not to create the 1984 trust.
Let me ask you, you mentioned the life insurance trust that paid Buck $1 million. Do we know the value of the Ford Trust in 1975?
Your Honor, I believe, and I'd have to go back and look, but at one point we did calculate the value of what those trusts would have been worth and what the stock in them would have been worth, and it was well below $1 million in 1975. And I'd have to go back to find the citation for that. But it dealt with the first motion for summary judgment, which was ultimately denied.
And considering the language in the MDA, is that the year that you would look to in making a determination about what Mr. Dunavant had to do to comply with the terms of the MDA?
Absolutely, Your Honor. I think that that's the only year that makes sense based on the other language in this agreement, and that you would need to look at that particular time where he could have determined this is the amount of life insurance that I would need to equal that amount. Otherwise, I have no other duty to maintain life insurance beyond what's already been arranged.
Okay.
Thank you, Your Honors.
Thank you.
All right, Your Honors, I have completed my homework. With respect to Judge Stafford's question, Tennessee law distinguishes the element of the meeting of the minds and the element of sufficiently definite to be enforced. And I referenced earlier Doe versus HCA Health Services, but distinguishing element 1 and 5, distinguishing those two. But importantly here, to answer your question on this, respondents never argued in the trial court that there was no meeting of the minds. Likewise, when you look at what they argued when this came to fruition in September of 2024 at this court, they didn't argue that either. Instead, respondents argued that the contract was not sufficiently definite. So this is a dispute over that. But if
But the trial court found there was no meeting of the minds.
Sort of sua
And
sponte.
the trial court found that the terms weren't sufficiently definite.
And I think respectfully to Judge Hurd that maybe there was a confusion between those two elements. But here's what clears that up. And let's look at Pharma and their reliance on the consideration statute. The same thing here. Under 4750-112A, Your Honor, because Mr. Dunavant had a written contract, and because he was the party to be bound and he signed it, then, it's presumed that the contract was formed with sufficient definiteness. And so I think if there's a meeting of the minds issue before this court now, that resolves it. With respect to Judge Bennett's question, with respect to the motion, we had asked, Your Honor, that the 1963 Dorothy Fisher Trust be made, that this court, take judicial notice of that from the Fisher case, which is also before Judge Hurd, along with the order on the summary judgment in that case. Those two things for one purpose, Judge Bennett, and that is just to show and confirm that the trust listed in 3A are irrevocable trust, because that was a bit ambiguous before. Mr. Geel's argument about Section 3D, our position, just to be clear, is that with the irrevocable trust in 3A and the fact that 3B requires Mr. Dunavant, it obligates him contractually to create an irrevocable trust in 3B for Buck's benefit, to put him on par with 3A, that if you look at 3D and say 3A and 3B are the inheritance, that's the universe, then it renders 3D meaningless. And I think, Judge Bennett, you honed in on exactly the fact that the primary mechanism of all of the bigger assets, the complete set of assets being transferred upon the death of Mr. Dunavant, was through the 2007 Revocable Trust. And because it's a revocable trust, that renders 3D meaningful under the contract, that obviously he could disinherit any of his children for non-arbitrary reasons. And I also want to point out that it is certainly our position that if you look at the March 2021 amendment to that 2007 revocable trust, that was well after we filed this case, so that the issue of enforcing 3B and the MDA was known to Mr. Dunavant and his counsel. And when he amended the 2007 trust in 2021 to say that certain assets under the 2007 revocable trust weren't going to buck. What he didn't say is that my obligation contractually under 3B of the MDA is not going to be performed for the same reasons. He didn't say it. And there's nothing in the record, Your Honor, that my client actually received the $1.3 million in round numbers under the 84 trust either. And that's because Judge Townsend ordered those monies to be paid out to somebody else, so, in the probate court, so.
Under your interpretation of the language in the MDA,
Oh.
Mr. Dunavant wasn't required to give all 5 of his children the same amount. Is that right?
Well, under the MDA, he simply acknowledges that the 1963 trust existed for their benefit, and those trusts we now know are irrevocable. In the 2007 trust, it's a revocable trust. So the provision of 3D, I guess, could certainly apply to that.
Do we know they're all revocable, or do we know that just one that was in the record?
Well, if I understood my adversary, I think he stated on the record that they're irrevocable, but to be precise, Judge Bennett, it's the Dorothy Fisher 1963 trust that we know is. So, and just to clarify, I may have misunderstood your question because you were referring to when each of them turned 30. Our expert would testify, if we ever got to trial, Your Honor, that to determine the average amount of the after-tax value received is going to be when the stock is sold. They would get the stock out of the trust, since that's the primary asset the MDA informs is in there. But to determine the average amount, after tax, it's got to be when that stock is sold. And that is an ascertainable number. I mean, in the record, we have our expert opinion, and that's based upon the stock ledger and the audits of this private company, this cotton merchant, over the long period of time.
I know you prefer it be 1993, but could Mr. Dunavant have looked at the values in 1975 and purchased life insurance to fund that trust based on an amount equal to what the 4 oldest siblings would have received after taxes, and we can determine what the tax rate is based on their income at that time?
Yes, he could, and it would be subject to Section 6 of the MDA, and our argument on that is, it says, the word maintain has a very clear definition in Webster's dictionary. And, if by 2020 it was a different number, Mr. Dunavant, one of the things we were precluded from obtaining discovery on, Judge Armstrong, was that he routinely is a very charitable man, and he used life insurance as a mechanism to fund big charitable donations through the Community Foundation in Memphis. And we were trying to get discovery because we knew that he often bought additional policies or increased the death benefit.
But if you determine the amount in 1990 and 1975, I don't see how paragraph 6 helps you, because 6 just simply says he has no further responsibility with regard to life insurance once he's met his obligation under 3B, that average amount.
But it also says to maintain as above. And what does it require above? Well, it requires Buck to be put on par with his siblings. And what does it tell us that means? It means that Buck's supposed to get the average of the after-tax value received by the 4 siblings.
Well, you reading to maintain the insurance for the benefit of Buck to mean that he's got to increase it, or just maintain it at the time it was determined in 1975?
Oh, I think that the ultimate damages number in this case, Your Honor, is the average of the after-tax value received. And if that's increased over time, then to perform the contract, it certainly could include, to maintain as above could certainly mean that he would have to increase that.
Okay.
Thank you, Your Honors.
Thank you. Thanks to all of you. Would you recess court for the morning, please?
All rise.